All right. Hi, this is Curt,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for February 3rd. It's a very important day, February 3rd of 2020. Oops, sorry, 2025. This is a happy birthday announcement for one of our loyal watchers, maybe two of them. I'm not sure, but Dr. Verone is one of our loyal watchers. And then one of our international fire law attendees. Faustine Curt is from France. She is she's a student studying law, I guess, from the judges part. They handle judges in France. They do judges a little bit differently than we do.
All right.
And you basically don't become a lawyer. You go into like almost like an arbitrator and a court clerk, and then you eventually progress to become a judge in France. So it's a little bit different than our system. But Faustine is also a firefighter, and her boyfriend is a firefighter as well. And Faustine spent a year here in the U.S. She was with us on our fire department here. And so she's a loyal. I think she uses it to practice her French, but practice her English. I'm sorry, but at any rate, happy birthday to both of those, and also my friend Marcus Coleman. It's a big deal, and my son Matt's dog. It's all four of them's birthday. So
I thought you were going to say Groundhog Day. He saw a shadow and more winter, but it's, if you want to skip over that, that's fine.
yeah.
Okay, let's with all that, let's start in New Hampshire. These are one of the things. It's a he said, she said. You don't know, but we have a New Hampshire fire chief. He was terminated back in 23, so fairly recently. He's filed a defamation suit as well as other things, but against other firefighters who claimed, kind of almost as a scheme, that he was making racist, derogatory remarks against some people who are Hispanic. I won't,
Yeah.
relay the remarks, but just, calling Hispanic people by bad names. And he claims, obviously, he didn't say it. So he's sued. And he's got an uphill battle in some sense. One, he's not only sued the department, what he wants to do, or sued the people making it, he sued the department, and he sued the individuals in their official capacities. So look, this is I don't want to say money grab. The way you grab money from people, most people can't afford to pay their losses. Even if you beat them, you still got to collect. So what you do is you try to sue the municipality or the employer. The problem is that you have to state that the employer made the comments in the scope of their duty. And typically an act that's criminal or that violates somebody's rights or that intended to inflict them harm, such in this case, are not done in the scope of someone's duty as an employee. So the employer presumably right now is making a motion to say there's no liability. Nobody, was supposed to make comments. And so this is what I see. So in the complaint, they said, well, you made these comments in the scope of your duty. And those comments were designed to interfere with me getting promoted and blah, blah, blah. But the problem is making comments may be in the scope of your duty, right? About people and their qualifications. But trying to make comments that are false is not within their scope of your duty. And so right. That's the scope that a court's going to look at, not that making comments and talking about things generally is your scope. So I think this is going to get dismissed as against the municipality.
You think, and I see what you're saying. It's almost like somebody on duty punching someone. It happened during like in the firehouse. It happened during the course of being on duty, but it was because it was intentional. It was really outside the scope of duties. But in this case, they made the statements as part of complaints to the department, and then the department utilized them. So I wonder if by couching it as a conspiracy, he's alleging that the conspiracy was within this, and I'm assuming he's alleging that the town officials, who the board of selectmen or whomever, were in cahoots with these two, I'm not sure if the conspiracy was just between the two perpetrators. But interesting here
It's a
in
tough
that
case.
he's already filed a wrongful termination case, and this he expressly in the complaint says that he is not alleging wrongful termination. That was he already lost the wrongful termination case. So now, and he says during the context or during the proceedings of the wrongful termination case, that's where he, for the first time, learned that these remarks were being attributed to him. So, interesting. Another just confusing thing here. I mean, I'm Italian American. Bruno is an Italian last name. I know
Right, right.
dozens, yeah, is Bruno. So I'm not sure where that Hispanic
Would even come
moniker
from. Right.
yeah came from. I mean, maybe, I'm sure it's possible that, he would be Hispanic with the last name of Bruno. But when I see Bruno, I just assume, oh, it's, Paisan. So,
Yeah, I don't know. In any event, I think he's got an uphill battle as against the
yeah.
municipality, maybe not as against the people. That's a question of fact.
Mhm.
And then the question is, well, will the municipality still provide a defense to the individuals? And that's
Yeah.
going to be based presumably. Let me show you how this plays out in the real world to our viewers, right? Because everybody wants the insurance to stay on the hook. So
Well, you do it, and you don't.
well, right. And so
You
see
know?
how it plays out. So the
Yeah.
person suing, right? The plaintiff wants insurance on the hook, right? Wants the town on the hook so
Yeah.
he can get some money.
Mhm.
The people who are accused of making the defamatory statements, they want the insurance on the hook because
They
they
sure
want to
do.
be defended,
That's right.
right? The problem is once the town makes the motion they should, or the municipality makes the motion they should and says they were not speaking in the scope of their employment, insurance is like, okay, you're right, we're out. And
Right.
and just making the argument could, I suppose, jeopardize the insurance, right? But nonetheless, this is going to be really, right? I mean, this
We
is a big issue.
we talked about this in the Kansas City case. Remember the Kansas City,
Oh yeah,
the guy who ran the
the
red light
accident.
and killed 3 people. In that, if you cut these guys loose, and I actually wonder if this guy came to me and we were strategizing. Of course, I'd have to be Rhode Island or Maine for me to give advice, but in one of those jurisdictions, we'd have to have a conversation that, look, if you want to prove a point, we're better off suing them personally
Yes.
and leave the city out of it, because then they're not going to have any, that they're going to have to either come in pro se or they're going to have to go find an attorney. They're going to have to spend a boatload of money defending themselves from your defamation suit. We're more likely to win that way. Now, you may not win any money, but if vindication is what you want, we're probably better off going after them without the town, because they're not going to be able to really mount a defense.
Exactly.
If money is your concern, then we've got to add the town in. So I don't know, a couple of interesting conversation that would take place between an attorney and a plaintiff in a case like this.
Yep, I'm smiling right now because as this came in, and I know we're live, but as this came in, I just got a really nice decision that I won it's a pretty big case for
Is
my
it
clients
the,
anyway.
the New York? Well, obviously New
No,
York,
not the one we're thinking.
not the
I
big
would
one,
like
not
to
the Seventh
get.
Amendment, not the Seventh Amendment case.
No, but I did get a very no, not that yet. That'll come. But I did get a very nice. As we talk, I'm gonna. And hello, viewers, wait for me. But so
Cool.
I'm just gonna
Cool.
send this
Is that
decision
Nicole
out to my
opening up a
clients.
champagne bottle in the back there? What's going on?
For
Yeah.
them, it would be that somebody was trying to shut down a multi-million-dollar corporation and
Yeah.
try saying that anyway, it didn't matter. But nonetheless, I won. So look,
There
I
you go.
lose every sometimes too. So okay, so let's go on to the next one now. Before anybody listens to what I say, before you pop off about, oh my God, there's, the no beard rule isn't being enforced, read Curt's caution warning on this decision that we're about to talk about from the U.S. Court of Appeals in District of Columbia does not hold that the no beard rule, cannot be enforced. Let's go to that. So here's basically what happens. Go way back to 2005. 2005, there's a lawsuit that challenges under the Religious Freedom Restoration Act, challenges the no beard rule. And strangely, I mean, I think we're head scratching here, right? But strangely, back then, the city didn't really rely on regulatory
They
issues or
goofed. They
science.
goofed. They goofed, and I'm not sure why. I've talked to Chief Rubin. I think Chief Rubin wasn't the chief when the suit was filed, but he was somehow involved in it after. I think they had already made the mistake. I'm not sure of the exact, but bottom line is the attorneys, the firefighters alleged that positive pressure SCBA alleviated any safety concerns related to facial hair at the interface. That was their argument.
Right,
Okay.
right, right. And people
And
have made
so
that.
now the attorneys are huddled up with the fire chief saying, okay, how do we respond to that? And apparently, whether the attorneys came up with it, the fire chiefs at the time, or people in the front office, the safety office, whomever came up with the argument that said, hey, after 9/11, every police officer and firefighter in the city was given a Tyvek suit and a negative pressure mask. And they were trained in it just in case there was a chem bio incident. And every police car and every fire truck has these things. And that's negative pressure. So why don't we just argue negative pressure? And then we don't even have to get into positive pressure. And it was probably groupthink. We're studying
Oh,
groupthink this week at Arizona State
stupid thing.
Forensic Psychology program. But the groupthink took over. Yeah, it's a great idea. And so they went forward with it. They conceded, which is crazy. They conceded the positive pressure, and they argued, negative pressure. And then, in the intervening years, still no one had ever actually used the negative pressure kits that they had. And so the judge looks at the city and goes, what do you say to that? And they say, well, it's possible. And they say, well, we're not going in that direction. So
now fast forward to 2020 and
right. Well, the court, let's go back to 2007. The court
Oh,
issued an injunction against the
yes.
enforcement of the no beard rule based on a strategic blunder by I don't want to say by the attorneys, there was a strategic decision made to argue A and not B. They argued A, they lost A, and they waived their rights to argue B. And, at any rate,
we never would have done that.
Of course not.
Right. The case, look, there's a
We're
lot
so
of
much,
cases on
we're
this.
so much smarter than them, right?
Of course we are. Of course.
In hindsight, everything's crystal clear, right?
But it is, to me at least.
but
But the case that people should be looking at, although it was done on some medical grounds, was the FDNY case about 3 years ago.
Oh, we've got a bunch.
Or Bray.
Yeah, we got a bunch. We got FDNY. I think we got one out of Chicago, one out of Atlanta. They all rule that if OSHA requires this is a federal requirement. Right. That the department is not free to just willy-nilly not enforce it.
Right. And if I'm so in 2020, just to show what happened is the department seeks to change their no beard rule, right? As part of COVID, et cetera. And then in 22, they sought to have the plaintiffs now seek to have the department held in contempt for violating the injunction way back. Mm-hmm. If I'm so the district court originally upheld the no beard rule, and then it gets reversed saying, no, this is about the agreement. Now, if I am the department, I am going back to the FDNY Baird Bray, something like that case.
I can get it for you.
Right? Yeah, because that one, the district court, they lost, the FDNY lost, they won on appeal. But here's what's so importantly similar in that case. They only had it was brought on by African-American men, black males, and they were shaving. And because the new OSHA rule, or I think it was an opinion letter, said, no, you have to be less than 24 hours clean. The FDNY said, okay, now we're going to require people to shave. And our practice of allowing them to have a little bit of stubble, we're reversing. So I raise that because the FDNY changed their policy to become in compliance with the new OSHA ruling. I don't think it's a rule. And the court said, the Second Circuit Court of Appeals, very influential, very smart court, federal court, said it's okay, right? You can change your past practice to become compliant with new standards. That's what they should be arguing. They should now get a second bite at the apple because there's been a change since 22 at least, I think, or 20 probably, a change in OSHA's, a little more stricter change, right? They become a little more strict, saying got to be less than 24 hours shaven. So I think, frankly, they should take a bite at the apple.
Yeah, I think to me, what they should have done was they should have went back and asked the court to rescind the injunction. That was
Prior
the
to
proper,
violating it.
right. In terms of just ignoring it, they should have went back. And again, here we go again. We're second guessing a decision and saying, oh, you should have done it this way, like we're clairvoyant. But in reality, I think that that's what should have happened. And maybe, in fact, that
Could
is
happen
what,
now.
yeah. And that would be the end of it. Brad, the case I got here is Daniel versus New York.
No, it's definitely a Bray or Baird, I thought.
All right, let me
It's Second Circuit Court of Appeals, and it reversed the district court.
see. I got Hamilton.
I could be wrong with the name, but that one sticks out at me.
Yeah, there's Hamilton, Daniel, and Lewis.
Maybe that's it. I don't know.
But both all three of those since 2018 through recent times. So
Okay.
yeah.
Any event, but the precedent is there, whatever the name of the case is, the precedent is definitely there that an employer can change its policies to comply with federal regulations or guidance in that case. Right. And it can change a past practice. And, that's such an important point. And maybe I'll add this to our must-have policies now. I have a statement. I don't know if you have one of your policies, but I have a statement about it's called the past practice policy. And it says past practices are not binding, and that we don't consider them binding. Just because we may have made an exception, they're not binding.
Bay.
Hey, see, I was pretty close.
There you go. I don't know why that didn't come up in my I got to check that one, but Bay is the case.
Yeah. There you go. Yes. Okay, let's go to Baltimore. Why not? And here we have, and this is important, this is the second case we've had like this. And let me give you the holding. So the holding of this case, before I give anyone the facts, is what you think is not necessarily what you could prove, and what your suspicions are do not amount to proof of discrimination, right? We had another case like this about 6-7 months ago where somebody said, well, I have a disability and I believe you're discriminating against me based on that. And they couldn't provide any proof. It's just, well, I told you I had one and you did these things, so that must be the reason because I have a disability. And the court comes out just like this court saying, your thoughts don't make the test. And so here, this individual files a race discrimination suit. He's a lieutenant in the Baltimore City Fire Department. And in 23, he alleged that white officers were targeting him after he had a verbal exchange with a female Baltimore County paramedic. Now, stop there for a second. Right there, he's defeated himself because he gave a second reason, an independent reason why they may target him. Oh, we don't like what you did to this female, so now we're going to treat you badly. You can treat someone badly. That's not necessarily illegal, right? But if you treat them badly based on their race or anything else, okay, that's not good. That said, he claims he became a target of race-based, wrongful, false, and frivolous complaints. And in short, the court did what I just told you. It says you have suspicions, but you didn't prove it. And they came back and found, provided a totally independent reason for their actions and why, by the way, you should be terminated. You can't just believe something is race-based. You have to be able to prove it. And, they did try to talk about, well, you compared yourself to other, right, to white people. And that wasn't enough. So what I like seeing in the courts is they want proof, not allegations, right? And I'm seeing out of some circuits, some circuit courts and some court of appeals, they're making it harder to prove, well, I was treated this way, I'm Black female, and white men were treated this way, so that must mean it's based on race. It's not. And lawyers are in a hard time, just like this lawyer, because they say, well, why would you treat me differently? Well, they gave you a reason. You gave a reason. You spoke out against another female and you pissed them off. Well, okay, that's a valid non-illegal reason, right? That's a legal reason to treat someone differently, badly. I'm not saying to discriminate against them, but anyway, but the court sets it out. You need something way more than just your personal belief. And I think that's the holding on this that I like. And these are the types of cases that I keep because I cite these types of things often, because most things I see are, oh, I believe the reason is this. And you said it a long time ago. This goes back to your courses that you're taking now. There are those people who can never accept blame, right? For anything, something's somebody else's fault. So it's nothing I did. It must be because I'm, protected class of some sort.
Right.
So I find the things, it's interesting. I find the interplay between the cases and the law, the cases we cover and the law we practice, and your degree that you're pursuing now.
It's that intersection between like leadership and the fire department, the law and psychology is just incredible. Yeah.
It really is. I'm trying to figure out why somebody would bring a suit. We used to say, oh, well, why would anyone want to go through this if it really didn't happen? On the other hand, it's that they really thought it did happen.
Yeah. Well, I'll say it again. This really, it came to my awareness shortly after I started practicing law. And I noticed a lot of people, I never knew them before. All of a sudden, they wanted to be my best friends, and they loved filing lawsuits. And yeah, they love that. And we would go to court. I would go to court. Some of these guys were friends of my dad's. They were clients of my dad's. And they were more excited to be in court than I was, and I was getting paid, and they were getting their jollies off. And there was a bunch of things that really led me to this conclusion. But the other one was when I first started subscribing to Lexis, and I'd enter a plaintiff's name into the Lexis search field, and I'd see, holy cow, this guy or gal is a litigation magnet, that they filed a suit here, they file a suit here, they file this, they file that. Might be suing a landlord, might be suing a neighbor, might be suing a person that they did business with. It's just they're like, they can't get away. They love, or they're somehow, intimately connected with our legal system, more so than me, who makes money off of it. It's right.
But if they keep winning, you could see why. So I'd be like, okay, that's how I get strength and power. Yeah. I sue, and the courts are saying I'm right.
Yeah, and I'm not saying I know nothing about this particular plaintiff, but there certainly is a connection. I say most well-adjusted people want nothing to do with our legal system. They don't want to sue people. They don't want the aggravation. They don't want the expense. And then there's other people who just, they love it, and they want to use it as a weapon to go after people. Yeah.
Well, in any event, the court got it right this time, right? Yeah. And people should be warned. Yeah. Yeah. Okay, to the biggest case. This is a huge case. I cannot believe the outcome of this case. I never would have predicted this, nor would I, if I was a judge, hold the same way. But here's the short of what we have. This is insane. So we have a funeral. We have an engine going to a funeral. And the engine's going to be driving down a street with a high rate of speed, I think, or faster than it is to fall out of a truck. In any event, in the engine, there are in the back, and imagine the engine, everybody, you know how there's a step up. Usually there's one step up into the cab, then another step up to the ground floor of the cab. And a whole bunch of people got in. There were 4 or 6 or whatever seats there were. There's 9 people total in back, but half are adults and have kids on their lap. And I don't know whether they're belted in or not, but in any event, then the woman gets in standing on that lower step against the door. And as they're driving, the door opens, she falls out to her death. So she sues, as frankly would I. And I mean, that's a good lawsuit, and she loses. I was shocked. All the insurance companies are thrilled. And what they said is, and I totally disagree with them, what they said, the court holds, they should appeal, despite that this is an appellate court, but the court holds, and maybe take a different view, but the court holds that the woman assumed the risk because everybody assumes a risk in the car. An adult assumes a risk of riding in the seat without a seatbelt. But I take so that's what the court held, right? She didn't put a seatbelt on. She assumed the risk. She's barred, right? Assumption of the risk is an absolute bar. By the way, for those who ski like you, right? If you look at the back of your ski tag, there's a whole bunch of letters you assume, or language, you assume the risk and all of this stuff. And so that's because you can't sue, because you know that like skiing is an inherently dangerous sport with risk of serious injury or death. And so they say you are assuming the risk. Here, what risk did she assume? Now, the court says, I really want to beat this up because I think it's important, because I don't want people to rely on this and be like, oh, so if somebody falls out of the back of our truck, they assume the risk. I don't think she assumed the risk. I think had she been sitting in a seat, didn't put on a seatbelt, and there's a law, right, that in the back seat of a vehicle, you have to wear a seatbelt. Not every state has those, right? New York has it if you're a certain age, but I don't know what, what Ohio has. But here's the thing. Did she assume the risk of the door opening up and her falling out? Or did she assume the risk of, okay, they hit the brakes hard, I don't have my seatbelt on, and I fly? Now, look, you can argue this, cutting it down the middle, a lot of ways. You could say she assumed every risk that came with not wearing a seatbelt. But here's the thing. The door flying open does not, to me, seem to be a normal risk. And what I would have said is the fire department allowed me to close this massively big door, right? You know, these engine doors are probably pretty big, or they shut it and didn't shut it. I don't know who shut the door. I didn't see that part, but I don't think she assumed the risk of falling out of a truck. I think she assumed the risk of slamming her head or coming out of the seat. But standing in a well, which is not safe, we would never allow our firefighters to do it. So we know it's a danger. Why are we putting that many people, right, in the back of a fire truck? I think it's a bad decision. I'm not trying to blame the fire department. I get it happens. We're like, okay, everyone get in. But the door wasn't shut. It wasn't shut properly by somebody. If they had her close the door, I think that's the problem. Those doors are not like normal car doors, right? They require force to pull back and close.
Let me go back. I think your analysis is the common law analysis, and it goes back to Palsgraf, okay? The infamous Palsgraf.
I got a great story about it.
Foreseeability of risk and all of that. And I think that's what you just said is exactly what we were taught in law school, and I think what most courts would find on the common law. The difference here is a nuance. I think I'm speculating in that there was an immunity statute, and the court analyzed it under governmental immunity, not under the normal Palsgraf standard. And so what we've got to look at are the history of how the Ohio Supreme Court has interpreted the language in the tort immunity statute. So I think you're absolutely right in everything that you said, but the difference here, and we really need our good friend Chip Comstock, right? And he may be able to, Chip, if you're listening and you want to call in on my cell phone right now, and we'll take up your your perspective. I don't really have a way to let him in. But I really think that this is a nuance, like almost like one of those holdings that needs an asterisk after it, kind of like the one one of the case we talked about in DC, that you really need to say this one's a little different than you might ordinarily be thinking. So I think that's it. But
I don't know. They get so much. I mean, I agree with you, but they go so down the line of primary assumption, the risk. I mean, that's, most of their holding, but yet they start with, right, the whole public immunity, et cetera. I don't know. I just think when a firefighter puts somebody in a position, and they put them there, right? And to me, I would argue she didn't assume any risk. Okay. The first thing I said here is at the beginning of my opening is, I don't think she assumed the right risk. I think the court missed the risk. I'm not sure she assumed any risk. The firefighter put her in the stairwell, right? And there were no seats available. When somebody tells you this is safe, I don't think you assume the risk. I think somebody told you it's safe. You relied on them to your detriment, and they're liable for the position they put you in. Nobody puts you on a ski slope, right?
Well, that certainly is the law under traditional common law.
Right.
And again, one of the things I thought was really interesting in this case, kind of like off to the side, was the fact that the court found a way around the NFPA standard that requires everyone to be seated and belted.
Yeah.
And puts specific responsibility on the driver not to move the apparatus. And the court said that does not, the fact that the NFPA says it, the fact even that OSHA may say it, or OSHA doesn't say it right now, but they might, you have the general duty clause that may kick in here as well. But even your own fire department policies in this instance do not create an enforceable legal duty. Okay,
and
now
that was tough. How did
well again, let's go back to my analysis using the iceberg and the Titanic, and because the court rules that the owners are not liable for the deaths of 1,500 people, does that mean that it's okay to go out and do it again? No. Our focus has to be on not allowing the harm to happen. And this is, the rightness or wrongness of allowing the harm to happen is different than the liability. And I think instinctively we think liability should track exposure to harm. But again, we're talking about really the taxpayer's liability for things that happen and not individual liability. If this was a private company that didn't have sovereign immunity or statutory immunity, then that would be one thing. But you're dealing here with quote unquote other people's money. Right. And I think the courts are a little they take a little bit of a sharper look at when you're dealing with other people's money.
And look, I'm shocked that, and I don't know if they did, I assume they did not. I'm shocked that this department, or at least it didn't get introduced against them because it would have defeated the NFPA issue. Don't they have a policy? But as I think about it, is because if they had a policy on it,
they said they had a policy. They had a policy, and they said that does not create a legal duty.
And if somebody violates a policy, that gets around the public immunity exception.
I'm not sure if you're aware of this, but that group of attorneys that came out with must-have policies have a little statement that specifically says in the policy that we are not creating a legal duty.
Right. Correct.
So here we go. We're rearranging the chairs on the deck chairs on the Titanic, But the reality is that I think under Palsgraf it comes out the way that you suggest. I think under the Ohio immunity statute, it will be interesting to see if it goes up to the Ohio Supreme Court.
Hard to imagine,
under Ohio law, under that immunity statute, this is the proper interpretation.
Yeah, and it's, assumption of risk has been beat up in so many cases across, I'm sure, every state. There can't be much new about assumption of risk. So there must be precedent on this. And then adding the significant, more than a nuance, whole, right, public immunity, all that creates a question that maybe the court, maybe the state's highest court will take it up.
Let me throw this out to you. If she or her family, the victim's family, had come to you as a plaintiff's attorney, who are you going after?
Oh, it's the fire department. 100% the fire department. I think the fire department.
I'm going after the apparatus manufacturer. Why did that door open?
Well, wait a minute. There are warnings in the manufacturer in the vehicle that says passengers must be belted, right? I presume, and then.
And that allows the doors to open for no reason.
Well, the reason I wouldn't go after that is you have to, now we've got to take the door off the engine, just so people understand what it takes to do this type of lawsuit, product liability, right? And I don't do them, but you have to take the door off, preserve the door, have it looked at, I think, simultaneously by the two experts as they deconstruct it on video to see if they can find a faulty lock. If they find a faulty latching mechanism, right, then the question is, was it not repaired, or did it come that way, or did it exist? Did anyone report problems on it? My bet is nobody probably reported problems. And here's what I'm guessing. I'm making this up, people. What I'm guessing is you got somebody standing in the well. If she pulled it, She didn't
Yeah.
pull it that hard because she would have knocked herself over standing in the well. We don't stand in the well and close those engine doors, right? If somebody pushed on the outside, same thing. They probably didn't want to push it that hard because they'd knock her over. Hence why somebody should be standing in the well. But let's go back to must have policies, because I just wrote this down. One of the policies I haven't done, I have it for parade vehicles. Nobody rides on parades. I'm going to expand this and we'll review it to send out, but nobody should be riding on back steps. Nobody should be riding on top of the engine. No backdraft stuff.
Ooh, I
Yeah,
can
I
hear the
know.
booze coming in. I can hear them coming in now.
Oh my God. Yes.
How about
And
this one?
seats are-
How about rather than that, how about like the vehicle shall not exceed 10 miles per hour or 15 miles per hour if people are on the back?
yeah, maybe. I guess it hurts less falling off at 10 miles an hour. But my fear about this, why I'm being so big about it, my fear about this case is people see it and be like, oh, pack them in. And if they get hurt, it's on them. I think this is a very one-off holding, despite it's a higher court case.
Yeah.
I'm having a hard time
I think
accepting
there's still another appeal left. They can still go to the Ohio Supreme Court, and maybe they will.
Right.
Maybe they will.
Right. And look, I don't want the fire department to lose. That's not my point. But we evaluate things fairly without regard to bias, right? And I'm just not positive in my mind. Again, you keep pointing out I'm looking at it from a common law, but I am, and I can't get around that.
Well, the fairness part of that, you strip everything else away from the law. There's a sense of fairness. If the law creates an unfairness, that creates a problem. And so the law should be fair. I think what you're saying is this is unfair. But when you look at it from that side, from the other side is it fair that the taxpayers have to bear the burden for a mistake made by a couple of individual firefighters? Now, if you're talking about holding the firefighters personally responsible, then maybe we've got a different aspect to it. But in terms of making the taxpayers pay for the mistake of the firefighters, I think that's really the orientation of the court on coming out the way that they did, I think, and through the statutory immunity. Right. So.
But we will deal with this on the must-have policy level for you and give you some suggestions. Maybe not as tight as your insurance company would want, but usually we offer different sample provisions when there are different ways to go. We will do that. But my personal belief is nobody rides without a seatbelt, especially if they are a non-firefighter. There's no reason to have a non-firefighter in the vehicle without a seatbelt. I'm not saying don't put non-firefighters in the vehicles. There are people who do. There are departments that do that. And the insurance companies want you to keep anyone who is not a member out of the fire truck. Why? Because you can't sue your employer generally. So
well, I almost sent this to Dr. Clark from the Fire Academy, who is like the national champion of riding seated and belted, and he and I have gotten into some interesting debates over it. And but he would be, I'm sure he'd be saying, "See what I said? See, isn't this what I told you would happen?" And so certainly, that aligns perfectly with his philosophy that you got to be seated and belted. Yeah, absolutely have to be. Yeah.
We do. That's it for the day.
Yeah. Oh no, we skipped one. I think we
skipped
over one. I think unless I was doing a little research, but we have that New Jersey Appellate Division. Firefighters can sue to challenge the collective bargaining agreement.
Oh yes. That, oh my God, it's huge. And I have it, and I'm just not jumping out at me.
Yeah, I'll jump in here. Okay. What we had was, and when you were saying that there was a case that you disagreed with, I thought this was going to be the one. But we've got some firefighters in Paterson, New Jersey, I believe.
This is a great holding. I think this is I love this holding.
Well, it's interesting. It's really interesting. It kind of it's counterintuitive on the collective bargaining part, but we've got firefighters who have a collective bargaining agreement that specifies how their overtime is going to be calculated. Okay. And obviously we have the FLSA. This is not brought under the FLSA. This is brought under the New Jersey wage and hour law, which is, I'm guessing is the same as the FLSA or similar to the FLSA. Certainly, Bill Macarone came up with the sort of the expression or the metaphor here that it's like building a house. Like you think about the FLSA as the floor. The state can always go to the second floor. They can go above it. They can't go in the basement. You can't go below the floor that the FLSA provides. So New Jersey goes above it. Now, the decision didn't really get into it, and to get into it, I think, would give us all a headache. So we don't need to get into the mistake that they're alleging happened. But essentially, what they're saying is that the collective bargaining agreement violates state law in terms of how to calculate overtime. And what they're doing is they sued to challenge the way that they were being paid. They didn't sue to challenge the CBA. But in essence, that's what you're doing when you allege that you're being paid improperly, and the way you're being paid is in the collective bargaining agreement. You're challenging the CBA.
But there's another provision of that CBA that they were using to support. Hey, we get to challenge it.
This was the defense. The city's defense is, number one, we're doing it the way the CBA dictates. That's sort of number one. And number two, there's a mandatory arbitration provision in there that if you don't like something that's in the collective bargaining agreement, your exclusive option is to go to arbitration. You do not have the right to take this to court. But there was also some provisions in the collective bargaining agreement that said that there's nothing in the collective bargaining agreement that limits firefighters' other rights. So now
that allows a violation of state law. And that's the part I think was really big for this court and this decision, right? The CBA said you don't get to violate a law by doing what we're doing. And it shouldn't have to, but it did. And I think that really helped them.
Yeah, it did. And I think what's important, I think if we keep in mind what we're talking about here are things like going in the basement. If, what they're alleging is the collective bargaining agreement brought them in the basement, whether the basement of the federal law or the state law, it brought them into the basement. If we're talking about something that is over and above the minimums that state law requires, and you don't like it, you've got to grieve it. But when you're talking about a statutory right to be paid in a certain way, and the collective bargaining agreement and or the city violate that, the individual firefighters they're not limited to going through the collective bargaining arbitration process. They can take it directly to court.
Yep. And so really, just to make this a little more general, not anytime, but probably most times that a state law says, listen, you have these rights if this law is violated. I believe just because the CBA says, no, these are the rights, or the process, mediation, arbitration, et cetera, if the rights are violated, you can't take away state law rights that are granted as the floor
but the
goes.
Supreme Court now, see, this is the thing. The Supreme Court, our wonderful Supreme Court now, has gone the other way, and they said that you can have a mandatory arbitration provision, and that can include things like sexual harassment, which I think is terrible.
Yeah.
You can have a mandatory arbitration provision that says if you are going to allege race discrimination, you're going to allege sexual harassment, you're going to allege all those, you have to arbitrate. That's ridiculous, because the individual doesn't own the grievance. The union owns the grievance. So now you have Miss A who's going to allege sexual harassment. And so she can't file a lawsuit. She's got to file a grievance. And the union says, yeah, we're not going to take it.
Right.
So, I mean, that's crazy. But our Supreme Court, in its infinite wisdom, has apparently said that, that's a good idea somehow. I
like a lot of their holdings recently, as people know. I'm using one of their holdings on a big possible case, but
well, I think they're so anti-employee. And I think you and I have, similar leanings in the big picture on most things. But I just think they're so anti-employee that they said, yeah, if they want to agree to it, that's fine. And I don't think that that's really a wise, insightful decision. I just don't.
No, I agree with you. I agree with you. I think this decision is correct, the Supreme Court. They got it right.
Yeah, and they also said that in order for that waiver of your rights to be effective, it has to be clear and unambiguous. And
you have to cite the law that you're waiving. I think that would hold. This court got it right, but I agree that some of the courts are going in the wrong direction. But that's why, and I don't do this specifically, but that's why people should be hiring a true lawyer who does the collective bargaining agreements. By the way, if anyone wants to see what a collective bargaining agreement looks like, if you don't know, you can see every single one of them because they're filed online. Places that have to file their CBA. So a great place to start if you want to read some of these that were at issue or may not be at issue. Look them up online. They're there and you can see. Not that every line is a good line, but this standard language nobody thinks about. We just put it at the end of contracts. Nobody ever thinks about it. And yet now it comes into play because I guarantee nobody ever thought about what the ramifications of a little line that says, you don't get to waive your rights and we're not taking away other legal rights that can't be taken away. But who'd think of it? Except that was important, not critical, but that was important to the court here. I thought that was big. So great case. Great. These are 5 great cases.
Yeah. Complicated and, all right, man. Well, that's going to do it for another edition of Fire Law Roundup. Brad, thank you very much. Next week, I am going to be in Indianapolis. So on the Monday, so we should be good for 1 o'clock if you're good for 1 o'clock. So hopefully that'll work out. If not, we'll have to work it around, but we'll be in Indianapolis, and then Tuesday is our FLSA conference. So
very good.
all right, that's going to do it for now. All right, that's going to do it for now.